Welcome to the Legal Broadcast Network. Joining me in the studio today is Brian Rubin of Rubin Law in Buffalo Grove, Illinois, a firm dedicated to special needs future planning. Rubin was in private practice, concentrating in estate planning, tax planning, and business law. That all changed in 1981 with the birth of his son Mitchell, who has autism. Since then, Rubin has dedicated his practice to special needs future planning. He is the president-elect of the Special Needs Alliance, a national, not-for-profit organization of attorneys dedicated to the practice of disability and public benefits law. Thanks for joining us today, Brian. Brian will be talking about why it's important for plaintiff attorneys to enlist the help of special needs attorneys in personal injury lawsuits. Brian, let's start off with what attorneys should look for when working on a personal injury lawsuit.
Well, the question is, will the plaintiff, if successful, ever be on government benefits where there's an asset or a resource test? In other words, if somebody is successful in a lawsuit and they're getting a settlement, if they are going to be on a government benefit program such as Medicaid or supplemental security income, where they would not qualify if they have assets in their own name of more than $2,000. They're able to place those funds into a certain type of special needs trust that's been around under federal law since '93, most states about the same time, and have those settlements as a reserve fund over and above government benefits and still be able to secure government benefits. When I talk about government benefits, I'm not talking just simply about a Social Security check for a few $100s. But I'm talking about Medicaid that would be paying for skilled nursing care, in services in their home, besides all medical bills, things like that. So we want the reserve fund to be a supplemental fund. If you go back to the history of this concept, going back to the early 90s, when this law was passed that allows this to take place, think of it this way. There's a small settlement. Let's say a child is received, maybe in a medical malpractice case, a settlement of several $100,000 after legal fees, etc. And now this child turns 18 and is eligible for a whole slew of government services and benefits, but they look to the child's assets and resources. If it's sitting in a guardianship account or in their own name, they're disqualified. If it's in one of these special needs trusts, commonly referred to as an OBRA, O-B-R-A trust, or a self-settled special needs trust, they're entitled to those benefits, and they can have this settlement as a reserve fund. To quantify it, as an example, let's say the child has Down syndrome, and they're looking for residential services for this child. In today's dollars, that means that the state with Medicaid would be paying anywhere from $60,000, $70,000 to a couple $100,000 a year for this child, in addition to all medical bills. But if they have a settlement in their own name or in a guardianship account, then they would have to exhaust all those assets before they would be able to secure the government benefits.
Should plaintiff attorneys worry about future liability in personal injury lawsuits?
Well, thank God for the plaintiffs bar knowing this pretty well in the past decade or so. We haven't seen the lawsuits, but there were a number of lawsuits filed for legal malpractice, professional liability in the early 2000s, where personal injury attorneys would have a settlement go into a guardianship account or into, for an adult individual who was their own guardian, into their own name, and then that individual was disqualified from government benefits. These type of trusts, depending on the state, can only be established until the person is 65, some states beyond. But if they have a plaintiff that turned 65 and never set up one of these trusts, they're not going to be able to set them up. So it's a matter of, I guess, doing the right thing for their person, not looking not looking at let's get them the settlement, but for the future of this person, let's let that settlement be a supplemental fund and not just trade dollars with the government, so to speak. The example that I've used often is that child who may have had a medical malpractice case, and that settlement when they turned 18 is going to be spent for the benefit of their child, but they could have been there for years to come in the future because they, at 18, they'd be able to secure government benefits without regard to parents' assets and income, only to their own resources. And by the plaintiff's attorney placing it in such a trust, they'll have their cake and eat it too, so to speak. What we try and do is two things. Is, I think you're aware, I'm president-elect of the Special Needs Alliance. What we try and do is twofold. One is to assist the plaintiff's bar in establishing these trusts and developing them and having them written properly so that they will be approved both by the federal government and state governments. But in addition to establishing them is talking about how much should be structured, how much should be outright or in a lump sum initially, what makes sense for this particular plaintiff. It's a second portion of the what value added that a special needs planning attorney can bring.
So, Brian, what you're saying is it's important for attorneys to collaborate with a special needs attorney from the beginning of a personal injury lawsuit?
You're doing it for twofold. One is that special needs planning attorney is going to be able to assist in determining exactly what government benefits will be available to this person and what won't be available. We'll also be able to assist in quantifying what the person's needs are going to be in the future and at what point those needs will occur. So when looking at the structures, to try and tie the structures into when the money is going to be necessary for the person.
How does a special needs attorney help assist an attorney in a personal injury lawsuit?
Two things. One is very often we'll have a situation where mom and dad are looking to use the funds for themselves or for the common good of the family, be it that trip to Disney World, maybe it's for a new vehicle, maybe it's for a new residence. These type of trusts that are held for settlements by federal law have to be what they refer to as sole benefit, S-O-L-E, sole benefit trusts. Nobody can benefit from an expenditure other than the beneficiary. So that if another family member may benefit, that expenditure will basically disqualify that trust. Therefore, what we special needs planning attorneys will do is work with the plaintiff's attorney in carving out a certain portion that could be a partial settlement to the parents, so that they're able to purchase the residence or purchase the vehicle. Maybe it's a van with a wheelchair lift or whatever it might be, so that it's not going to be a problem later on. There's another part of this besides the Medicaid aspect, and that comes in technically for workers' compensation, but it looks like down the road we're going to be talking about third-party liability cases, and that is what they call Medicare set-aside trusts. Medicare, when there's a settlement like these cases for workers' comp, and now it looks like they're going for third-party liability cases, are saying Medicare's not going to pay unless from the settlement there's a set-aside certain amount, which is a projection of what medical bills will be paid and will be needed in the future, and it's put into one of these trusts to protect Medicare. So all of these things, the Medicare set-aside, planning for Medicaid, are aspects that the special needs planning attorney is going to bring to the table to assist the litigation attorney.
We appreciate your time today, Brian.
No problem. Take care.
And thank you for watching the Legal Broadcast Network.